Yes. Just looking at this assessment, yeah. That was in August 11th. Yes. On In August of that same year, you issued a protection order. Then you reissued it after you arrested me, 1 week after she filed for dissolution of marriage, when I was found not guilty of attempting to contact her through Healthy Families of Clallam County. And then you continued to reissue it. And the last one that you reissued, you used a forgery and fraud to accomplish it. Now, the recommendation was for reconciliation. Some counseling as a married couple that had 6 kids. And there was no child abuse, assault, or family violence. There was an argument that took place on the 2nd of July of 2011 about spending half of the welfare on new clothes for my sons. Now, an evaluation assessment on August 18th of 2011. Parenting classes, right, and reconciliation counseling so that we could continue as a family. This was received on the 22nd of August 22nd of 2011. You issued a protection order, a permanent protection order, when you kept putting this: no contact until there is a mental health evaluation of respondent and treatment if recommended. Did you see any treatment recommended? Did you see any psychotropic medication? Did you see anything about me having mental health problems? Is there anything in this assessment that suggests that I'm mentally ill or mentally what? August 11th of 2018. How is it possible that this dumb fucking court doesn't realize that the RCWs require the appearance of the petitioner and the title petitioner motions of court? How the fuck is it that you thought you had the authority to issue a court order without the actual signature of the individual that petitions the court? How did you think that? Whose signature is that? Is that the actual signature of the Clallam County Clerk? Or is that the signature of some other employee that saw it? Well, it doesn't matter. We sign these things all the time. It doesn't violate election laws. We can sign any fucking thing we want because this court does not understand the requirements of the law. Now, let's look at this. August 12th of 2011, you issued a permanent protection order. I was being evaluated on August 18th of 2011. How can you issue a 1-year protection order when I'm on Guam? Yes, I was not given notice of court hearings, and you didn't want to hear that we had an argument that morning. How the fuck is it that Washington State can do the shit that you do to people and then think that I want you to remove your fucked up law? Do you understand? You had no legal right to issue this order for protection without me receiving notice and opportunity to be heard, and then presenting this to the court that I did have a mental health evaluation, and the treatment recommended was 7 hours of parenting classes. It wasn't psychotropic medication. It was an antipsychotic medication. And it sure the fuck wasn't a mental facility where I didn't commit any crimes. And this